Alright, Part 389, Subpart B, Procedure for the Adoption of Rules. 389.11, General, except the providing 389.39 Directive or final rule making procedure in life of the administrator for the good cause of the final rule and practical and necessary contrary to the public interest, and incorporate such a finding in the brief statement of the reason for it and the rule of the notice proposed rulemaking it must be issued. Interested persons are invited to participate in rulemaking proceeding involving the rule under Act. 389.13, initiating the rulemaking. An administrator initiate the rulemaking his or her own motion, however, in so doing, she or he or his or her discretion considers the recommendation of his or her staff of the other agencies of the United States and other interested persons. 389.15 contains the notice of proposed rulemaking. Each notice of proposed rulemaking published in the Federal Register unless all persons subject to it are named and all are personally served with a copy of it. Each notice, whether published in the Federal Register or personally served, includes a statement of the time and the place of the nature of the proposed rulemaking, proceeding the reference for the authority under which it is issued, with a description subject of the issue involved in the substance for the terms of proposed rule, statement of the time within the written comments that must be submitted with the statement and how to what and interested parties might participate in the proceeding. 389.17 participating by interested person. The interested person may participate in the rulemaking proceeding by the submitting comments for the written with the containing information, values, and arguments, and his or her discretion. Administrator may invite the interested person to participate in the rulemaking procedure described in 389.25. 38.9.19. Petitions examined at the time of the comment, with the petition extension for the time of the submit of the comments must be received with the duplicated no more than 3 days before the expiration of time statement stated in the notice of the filing of the petition does not automatically extend for the time of the petition or comment if the petition is granted only with the petition or show of the good cause of the extension. The extension is consistent with the public interest. The extension is granted to all the persons of the publisher in the Federal Register. 389.21. The content of the written comments. All written comments must be in the English for the interested person must submit as part of his or her comments all material that his or she should consider relevant. Any statement of the fact during him or her incorporation of the material by references to be avoided. However, in such incorporation and necessary, the incorporated material shall be identified with respect to the document in the page. 389.23. Consideration comments received at the time of the comments are considered before final action is taken. The rulemaking proposal later filed with the comments may be considered as far as practicable. 389.25. Additional rulemaking procedure. The administrator may issue any of the further rulemaking procedures whether he or she necessary or desirable for any interested person may be invited to make oral arguments to participate in the conference between the administrator and his or her representatives. That the minutes of the conference are kept to appear in formal hearings presided over an official designated by the administrator, at which the transcript of minutes are kept, and to participate in any other proceeding to assure to informed administrative action and to protect public interests. 389.27 hearing. Section 556, 557 of the Title 5 of the United States do not apply with the hearings held under this part unless otherwise specified. Hearings held under this part are informal and non-advisory to fact-finding procedures at which the normal formal pleadings advisory parties. Any rule issued in a case of the informal hearing is held not necessarily based exclusion on the record of the hearing. The administrator designates a representative to conduct any of the hearing held under the part of the Chief of the Council of the Federal Motor Carrier Safety Administration designates a member of his or her staff to serve as the legal officer at the hearing. 389.29 Adoption of final rules. Final rules are prepared with a representative of the official concern with the office of the Chief of the Council for the rules submitted with the administrator for his or her consideration. Administrator adopts the rules and publishes Federal Register unless all the persons subject to it that are named are personally served with a copy of it. 389.31 Petitions of rulemaking. Interested person may petition with the administrator to establish a manual of the repeal of rules. Each petition filed under the section must be submitted with a duplicate of the Administrative Federal Motor Carrier Safety Administration, 1200 New Jersey Avenue, Southeast Washington, 205900001. Set forth the tax substance for the rule amendment for the proposed specify the rule for the petitioner seeking to have the repeal that the case may be explained the interest of the petitioner with the action requested containing any information or arguments available to the petitioner to support action sought. 389.33 Process of the petition. Unless the administrator otherwise specifies no public hearing, argument with the other proceeding held directly with the petition before disposition under this section, grants if the administrator determine the petition contained with the adequate justification he or she initiates the rulemaking under this Subpart B. C. Denials of the administrator determine that the petition does not justify rulemaking. He or she denies the petition. Notification whether the administrator determines that the petition should be granted with the denied, but the office of the Chief of the Council prepares the notice of the grant and denial for issuance of the petitioner of the administrator of the issue to its petitioner. 389.35 Petitioner for the reconsideration. Petition for reconsideration. Any interested petitioner may have the petition of the administrator for the reconsideration rule issued under the part of this petition must be in English and submitted to the Administrator of Federal Motor Carrier Safety Administration, 1200 New Jersey Avenue, Southeast Washington, D.C. 205900001. Received no later than 30 days after the publication of the rule with the Federal Register. Petitions filed after the time of the date considered the petition filed in 38931. With the part petition must contain a brief statement of the complaint with it as an explanation to why the compliance with the rule is not practical, unreasonable, and it is not public interest. If the petitioner requests for the consideration of additional facts, he or she must state the reason why they were not represented by the administrator within the prescribed time. The administrator does not consider repetitious for petitions unless the administrator otherwise provides the filing of the petition under this section does not state the effectiveness of rule. 38937. The proceeding of the petition for the reconsideration. Administrator may grant within whole in the part of the petition of reconsideration without further proceeding the event he or she determines if the reconsidering any rule he or she may issue final decision of reconsideration without proceedings. Further proceedings he or she may provide such opportunity to submit the comment with the information with the data he or she deems appropriate. Whenever the administrator determines the petition should be granted with a denied, he or she prepares the notice of the grant and denial with the petition for the reconsideration or issuing to the petitioner issues to the petitioner. The administrator may consolidate petition relating to the same rule, 38939. Administrator may consolidate petitions relating to the same rule, 38939. Direct final rulemaking procedures. Direct final rulemaking regulatory changes the states for the change of the bill is taken effect with a specified date unless the Federal Motor Carrier Safety Administration receives the diverse comments for the notice for the intent of the file of the diverse comment by a date specified in the direct final rule published in the Federal Register. Type of the actions appropriate for the directly final rulemaking rules of the administrator determines to be controversial and likely to result in the inverse public comments, but adverse public comments may be published in the final rules section of the Federal Register as direct final rules. These include non-controversial rules such as making non-substantial clarification, correction, existing rules, incorporating by the reference latest or otherwise updated version of the technical industry standards affecting the internal Federal Motor Carrier Safety Administration procedures, such as filing requirements, rules of governing inspection, copying with the documents, updating existing forms, and making minor changes of the rules and regarding statistic reports of requirements, such as changing in reporting periods, for example, for the quarterly and annually, eliminating type of the data collection no longer necessary. Reverse comments. The comment is the Federal Motor Carrier Safety Administrator judges to be critical of the rule, to suggest that the rule should not be adopted, to suggest the changes should be made to the rule under the direct final rule. The process of Federal Motor Carrier Safety Administration does not consider the following type of the comments to be diverse. Comment regarding recommending another rule change unless over the comment or state that the direct final rule will be ineffective without change. Comments outside of the scope of the rule. Comments suggesting rules, policies, requirements should not be extended to other agency programs outside the scope of the rule. 3 comments in support of the rule. Comments requesting clarification, confirmation, effective date. Federal Motor Carrier Safety Administration published federal rule document in Federal Register. If it has not been received, verse comment of the notice of the intent of the file, the verse comment of the date specified by the direct final rule. The confirmation of the rule docket tells the public of the effective date of the rule. Withdrawal of the direct final rule. If the Federal Motor Carrier Safety Administration reverses the verse comment, notice of the intent of the final adverse comment within the comment of the period. If the published rule of the date document in the Federal Register before the effective date of the direct final rule, reversing public and withdrawing with the direct final rule. Alright, if the Federal Motor Carrier Safety withdrawal of the direct final rule because of the adverse comment of the agency may issue the notice of the proposed rulemaking if it decides to pursue it with the rules. Affidavit in support request for the confidentiality, and then it goes on to Part 390, Federal Motor Carrier Safety Regulations General. And that was Part 389.